This is Michael Popok, and this is Legal AF After Dark. Colorado and Maine are just two states whose either court systems or Secretary of States have determined that Donald Trump is not only an insurrectionist and or a rebel against the Constitution, but that he has no place on the presidential or primary ballots, and they've taken steps to remove him. Of course, it's going to end up right where we thought, on Legal AF with the United States Supreme Court, who's already taken up the Colorado case, which was ruled upon by the Supreme Court there, and I'm sure will also take on the Maine decision by the Secretary of State there to deny Donald Trump any place on the ballot because he's not qualified under the 14th Amendment, Article 3. That's the headline, but here's the detail in our most recent episode of Legal AF. Take a listen.
Let's talk about these disqualification cases where they are all at. Michigan Supreme Court saying they don't have jurisdiction to hear disqualification challenges. The Colorado Supreme Court decision disqualifying Donald Trump, and that Supreme Court decision was appealed to the United States Supreme Court by the Colorado Republican Party. Notably, Donald Trump has not filed his petition for certiorari yet, I guess waiting again to the last minute there. And then you had the Secretary of State of Maine, and this surprised many. You know, she held a hearing, though, December 15th, and thereafter just said, look, I'm being asked to reach a decision as a Secretary of State. Is the 14th Amendment, Section 3, self-enforcing? I think it is. Was January 6th an insurrection? I think it is. Was Donald Trump involved in that? I think he was. Is Donald Trump an officer? I think he is. So what do you want me to do? That's basically what the Secretary of State said. I have to render this decision. It seems pretty clear to me. And that's the decision. So I'm saying that Donald Trump is disqualified. That's my role as the Secretary of State. I don't do this lightly. I understand that no Secretary of State has done this, but I feel I'm duty bound to follow what the law is. Donald Trump immediately, puts her contact information to the public so she can receive death threats, because that's how MAGA responds to things. Her decision, like the Colorado Supreme Court decision, is stayed pending, kind of a further judicial process. In Maine, it will now go through the kind of court system after to see if she acted within, I guess, the appropriate scope of her authority. It'll go through the Maine courts, and then ultimately, that could be consolidated before the Supreme Court. But I want to get your take on it. I'll just share this one tidbit. The reason that we're here, though, in the first place, is we should never be here in the first place. The only people who are politicizing this issue, frankly, in my view, is today's modern day Republican Party, the modern Republican Party, the MAGA. Because you have great former Republicans, or now I guess called rhinos, and constitutional scholars like Judge Ludwig and others, strict textualists and people who are, formerly with the Federalist Society or still consider themselves Federalist Society members, who look at it and say, here's just what it says. The problem is we've had in Donald Trump and an entire political party, and I think the framers of this specific amendment in the kind of Reconstruction era did not contemplate that you could have an insurrection. We could all see an insurrection take place, yet the major political parties will rally around the insurrection and the insurrectionist and support it as a legitimate political, peaceful, patriotic event that's taking place. So therefore, if you oppose that, that's somehow, you're politicizing it, and you are, you are overreaching your kind of, jurisdiction if you're a Secretary of State doing this. But I think, Popok, common sense informs, and if strict textualism, if our Constitution matters, and the other provisions matter, I don't know, it says what it says. That's it. It says what it says. And Donald Trump engaged in an insurrection, and it shouldn't be hard, but you do have, and I think this is the kind of the saddest state of our country right now, the Republican Party, MAGA, which it is now, because I think the Republican Party pretty much is dead, supports this as, their day, that's their rallying call. And so when you call it what it is, it's like, oh, you are attacking us. No, just you try to overthrow our government. You try to overthrow our democracy. Like we all saw what went down. Popok, maybe take us through some of these disqualifications.
Yeah. Colorado, 4-3, of course, finding under the uniqueness of Colorado law. Actually, let me take the plane up 5,000 feet and look down for a minute. In our system of federalism, states, individual states, and their individual statutes and their individual Secretary of States have a role to play in who becomes our president. That might seem odd to people, especially from those outside of the United States, but that's one of the bargains that we have baked into federalism. There's federal government and federal practice and federal law and federal agencies, and then there's state by state. And one of the ways that we were able to put together this great United States is because of the compromise between large states and small states, and how to fit them all together and have any kind of power and electoral college versus popular vote and that kind of fight. But every state individually, based on its own unique statutes, determines how somebody's going to vote, when they're going to vote, how they're going to vote, what kind of ballot they're going to use, who's going to certify that, how that person got appointed or elected to the position, absentee ballots, mail-in ballots, using boxes, no boxes, early voting, no early voting. That's why if you're in one state and I'm in another, Ben, I probably use a different ballot than you. I voted at a different time than you. I may have had the benefit of early voting. You might have had a longer early voting period. I might have been able to drop my ballot off at a box. You may not have been able to. And some people outside the country is like, what are you talking about? Why isn't it just like an ATM machine? Everybody shows up at 9 to whatever over a week period and votes. Yeah, that would be if you want to not suppress the vote and you wanted everyone in your country to vote. That's why in other European countries, you see voter turnout at like 70% because they make it really easy and they don't put barriers to entry and barriers to voting. So you have that system. And most states, the Secretary of State is the one through the statutes that it's empowered to do many, many of the things. And then it devolves down to clerks and of the various counties or other municipal things. That's that. Then you got Congress and the Constitution that federally sets certain requirements and statutory provisions related to the presidential election. But everything else, time, place, manner, voting, ballot, that's all state stuff. And we've had a long line of Supreme Court precedent that says exactly that, including some that has been cited by and used by people that are currently on the U.S. Supreme Court, like Neil Gorsuch, who, when he sat on the 10th Circuit, had a very similar case about a presidential candidate being barred from a ballot, and it's called the Hassan case. And Gorsuch, before he was a Supreme Court justice, said, hands off. It's a state-by-state issue. It's a state power issue. It's not a federal issue. They can decide. Now they're going to have to decide this issue at the Supreme Court level through the Colorado case, maybe the Maine case. They're going to have to, the Supreme Court's going to have to make a decision as to whether this waterfall of events that happens across America in the various 50 states with maybe 50 different outcomes because of the unique state provisions that are being applied to federal to presidential qualifications for the ballot, right, come to a head with somebody like Donald Trump that wants a federal decision that's uniform everywhere, not happening, about his entitlement to be on the ballot. And then you've got, well, if Congress and our very Constitution is based on this division of labor, if you will, between the state and federal government, then when the 14th Amendment and Section 3 was adopted during Reconstruction period in American history, didn't they anticipate, and the answer I think is yes, that the states, through their secretaries of states and otherwise, would implement the 14th Amendment and Article 3? Otherwise, how would it be? I think we all agree on both sides of the aisle that it's not language that's sitting on the Constitution for which we should just ignore it, and it's just surplusage. It's just extra words that just happen. They needed to fill in, they were printing it in a certain way, and they needed to fill in a section. Well, let's just make up a 14.3. No, you have to be able to effectuate that language. And the battle for the U.S. Supreme Court, whether you call it the Colorado case or the Maine case, is going to be, how do you effectuate the 14th Amendment, Section 3, the disqualification clause? Who does it? If it's supposed to be the states, which, as you can see from my presentation, I believe it is, okay? If it's supposed to be the states, then courts would seem to be the natural place to adjudicate whether someone engaged in insurrection or rebellion against the Constitution, because how else do you determine that if it's not the court system? If it's not the court system and it's a political question, because it sounds like politics, so people think, oh, it's political question doctrine. Can't take it away from the courts, take it away from the Secretary of State. It goes to Congress. Well, where does it say that in the 14th Amendment? It doesn't say that. It doesn't say that in the legislative history. It doesn't say that in the text. It's very easy for them to have used a quill pen and written in the 14th Amendment. And this issue of engagement shall be determined through a trial of his peers or through Congress, through another proceeding. It doesn't say that. They figured out, they thought, the framers of that provision, that we were smart enough in 2023 to know what they meant about how to determine who engaged. They gave us the language, and then they figured out, you guys will figure it out. Don't worry about it. But it's not what Donald Trump.
You know it when you see it. You know one when you see one.
You're an engager. Doesn't say convict. Doesn't say convicted. There was no way, and there's nothing in the legislative history to the contrary, that they wanted America to go through trials, basically military trials of Confederate leaders like Jefferson Davis, to have him tried first, branded an insurrectionist or a rebellious person before determining whether he could stand for office. No, it was a loyalty test. They had many loyalty tests. Now, I've seen one argument, Ben, about, well, it doesn't apply to the president. We've talked about this at length. But this argument is it doesn't apply to the president because the title civil office, civil or military office under the United States has historically meant civil servants, and like the postmaster and not the president. If they wanted to say the president, why didn't they use a big P with their quill pen and write in president? Because the legislative history says they put the catch-all in any office under the United States, civil or military, and that captures the presidency. So that's going to be the fight. It's going to be this federalism fight at the Supreme Court level about the role of the states in doing their job about elections. And that's what Shauna Abello said, the very brave Maine Secretary of State. She's the first one to have ruled that he's off the ballot. Colorado Supreme Court said that the Colorado Secretary of State could get around to taking him off the ballot, but that got stayed pending the Supreme Court decision. Shauna's taken him off. He is off, and she's not staying it. She said, I had no choice. I was appointed by the Maine legislative House, the House and Senate, to be the Secretary of State of Maine. It is my job under the statutes of Maine to look at whether somebody has falsely and fraudulently petitioned to be on the ballot. And I find that Donald Trump committed falsehoods, right? He made false statements saying he was qualified when he was not. Now, what was the basis for that? It was primarily the Jan 6 report. You and I talk, I always look for my copy. We talk a lot about the Jan 6 report. That was an exhibit to the petition. And then lastly, I'll leave you on this, Ben, as the record goes up, as it is, to the U.S. Supreme Court. Donald Trump barely participated in the Maine proceeding. He filed 2 briefs, one about Colorado and how it impacts Maine, and one just a general opposition brief saying, no, speech, I have free speech, First Amendment, you can't take me off the ballot, and you don't have the power to do that, and everything else. And the oath of office is wrong, and I'm not covered under the 14th Amendment, all those arguments. That's it. He did not put on a witness, an expert witness, evidence, testimony, nothing. The other side, expert analysis, testimony, similar overlapping witnesses in the Colorado case on the 14th Amendment, its basis, its background, legislative history, to guide the Maine Secretary of State in her decision making. And then lastly, she's a partisan hack. She's a Joe Biden puppet. I don't know about all that. She spent her entire life in public service. She grew up, I did this on a hot take. She grew up in a house that didn't have running water or electricity until the 5th grade. Father's a carpenter, mother was a nurse. Okay. She's self-made in every material way, but has devoted her entire life to public service, starting in the Peace Corps, AmeriCorps, ACLU, and the Holocaust Museum director in Maine. And she was in the House as a member of the House of Maine until she was appointed and selected by her peers to be the Secretary of State. Donald Trump just doesn't like that we have a state-by-state process to guide our election our election processes. That's where it sits. And that is inherently political because people either run for office or they're running on a ticket. And that's just the way it is. And you don't get to throw over that entire constitutional framework because you don't like the results. The question is now, Ben, with Colorado, with Maine, with Michigan, obviously the Supreme Court's going to have to weigh in. Are they going to rule? I want to get it from you. Are they going to rule based on the text of the Constitution and its history that the 14th Amendment applies to Donald Trump and it is a state-by-state decision based on how we determine who goes on the ballot? Or are they going to say the states have no role in this and it goes over to Congress as some sort of political question, or there has to be a conviction of Donald Trump for insurrection or rebellion in order to keep him off the ballot? What do you think?
Well, if they're states' rights, strict textualists, you'd expect the decision to be very easy and to allow the states to go through this process. I think, though, the Supreme Court, given its current composition, will probably find some way to stay the enforcement of these decisions post election. I don't know if they will cite the Purcell principle or something and saying, hey, we're too close right now and we want to have a longer briefing so you stay on in 2024, and then they'll try to punt the issue. I have a very low bar for what I ultimately think the Supreme Court will do on an issue like this, which shouldn't be novel, but is novel, which I have a different view of what the Supreme Court will ultimately do when it hears the issue of absolute presidential immunity, because the Supreme Court has a body of case law there, and Donald Trump's arguments cut directly against what the Supreme Court's view is of Article 2. And because there's also a self-preservation aspect to Donald Trump's absolute presidential immunity argument, which, if you take it to its logical conclusion, Trump can take away the jobs of Supreme Court justices and be absolutely immune from that as well. I think the Supreme Court justices kick in on their selfish gear on the absolute presidential immunity argument. Unfortunately, I think they try to find some way to procedurally not get at the issue here of in Colorado as well as Maine. But we'll see. I'm interested.
I think he stays on the ballot. I think you're right. The self-preservation I thought you were going to talk about was John Roberts trying to preserve the Supreme Court and its legitimacy, because all of these things put the
that went out the door and died.
There is none. But I think they keep him on the ballot. And again, politically, I'm not sure that's a bad thing. If Joe Biden's going to win, I want him to win in 50 states. Which he's going to. He's not going to win all 50 states, but I want him to win with him on the ballot. And I don't want to make Donald Trump a bigger martyr than he's already and a grifter than he already is. And if he gets permanently banned from 2 and he's down to 48 states, it'll just activate his base in a way that, I don't really know what the outcome is going to be. I don't need them more motivated to vote for him and or to give him more money than they already are. So there is the flip side to this. And that's just a pure selfish political analysis having nothing to do with the law.
But I don't. I'll tell you, the part where I disagree with you about the activating his base part, and I saw the New York Times do an article about that too. And frankly, I'm not criticizing your logic there, though, Popok, in saying it. But to me, I just think we shouldn't give a crap about what people who say the most hateful and disgusting things and watch the insurrection and think it's a great thing and want to overthrow our democracy. If they want to be active and engaged, the time needs to be spent just calling out how horrific the underlying conduct is, and that's what we're going to be spending our time on. Just one point to make about the decision reached by the Secretary of State in Maine. She wrote, given the compressed time frame, the novel constitutional questions involved, the importance of this case, and the impending ballot preparation deadlines, I will suspend the effect of my decision until the Superior Court rules on any appeal or the time to appeal under the applicable section.
The Maine Superior Court, yeah.
The Maine Superior Court, correct. Yeah. So there's the enforcement of that's temporarily, I would view that as being temporarily stayed. There's 5 days from the date of that order to appeal basically the decision and go through the Superior Court process.
Well, There's an example of what we do on a curated podcast at the intersection of law, politics, and justice we call Legal AF. It's every Tuesday. Where am I? Sorry. It's every Wednesday and Saturday. You can tell 2024 is just upon us. 8 p.m. Eastern Time on the MeidasTouch YouTube channel and then on audio podcast platforms of your choice. If you like lawyers talking about things, they know what they're talking about, Legal AF is for you. If you know about us already, thank you for being along for our journey. If you have no idea what I'm talking about, that was Legal AF. I am Michael Popok. And until the next episode and my next hot take, this is Michael Popok, Legal AF, signing off.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.